Welcome to the seminar on institutions, markets, and migration, organized by the Department of Institutional Studies at Metropolitan-Autonomous University Cuajimalpa Unit. We are grateful to have the presence of Jorge Enrique Culebro, the head of the Department of Institutional Studies, who is going to give some words of welcome for our keynote speaker, Professor Geoffrey Hodgson. Thank you, Professor.
Buenos dias. I'll just share my screen with you.
Thank you very much. I just want to say a few words and give, on behalf of Esther Morales, a warm welcome to Professor Geoffrey Hodgson. For us, it's a very honor to listen and to have you here virtually, and we really appreciate that. And we are very thankful to have you here. And please feel free, very welcome to this university. Thank you very much, Dr. Geoffrey.
Thank you very much for your warm welcome. I only wish I could be in Mexico with you. It's a wonderful country, but I hope you can hear me from distant Devon in England. Please tell me if you can't see my slides. This is the structure of my talk on formal and informal institutions. This distinction is very important in institutional analysis. I'll explain what it means and some implications of this conceptual distinction. Unfortunately, we do have people that use the words formal and informal in this context, sometimes without defining the meaning, or using the words loosely without precise meaning. Part of the argument in my talk today is to argue that we must try and use these words more sharply and clearly. That means we have to think about definitions. This is the basic first step of the conversation we're going to have to establish meanings of these key words. Now, matters of definition are different from analysis or causal connection. What we're simply doing is establishing the meaning of words. This is true in any language, English, Spanish, anything. In scholarly discourse, it's important that we say what we mean by a word so that others can understand us and we can together carry out analysis and try and understand the world. So we need to think about definitions and meanings. And then after we've done that, we can talk about what matters. I'll try to do a bit of both in my talk. We can investigate causal interactions between formal and informal institutions, for example. And understanding formal and informal institutions is especially important for economic development. I'll try and explain that point. The distinction in institutional analysis between formal and informal institutions is relatively recent. It became prominent in the 1990s. And one person above all others who established or promoted this distinction was someone I'm sure you recognize, Douglas North, who won a Nobel Prize in economics in the 1990s for his work on institutional economic history. And he promoted the distinction between formal and informal institutions from about 1989. And he had a big effect on the literature in this area by establishing these important concepts. But sometimes North's writing is a bit confusing because he adds other words and it's not clear why he has to add these words. So he distinguishes between formal rules and informal constraints. But if you think about it, a constraint is really a rule. If it says no trespassing on a piece of land, no trespassing. That's a constraint. That means we can't trespass. It's also a rule. So why does North use different words? And he does this quite consistently. So there's problems raised sometimes by lack of clarity of this kind. But what North was more clear about is that he largely associated formal with constitution, laws, property rights. These are basically legal concepts or law-related concepts. And I'm suggesting that we follow North in that regard. We look at formal as basically being related to law. Other people use the written or not written distinction. So formal is written down, and informal is not written down. I think that's a weak distinction, and it's not nearly as powerful as the one that North promoted. Why? Because a lot of rules can be written down. I mean, we now have books of etiquette, including rules for table manners. Now, these are not laws, but if you go into a country and you want to know about its customs, you read about the customary rules. There's rules of language. There's rules about Spanish. There's rules about English. For example, in Spanish, you often put the verb, a noun before the adjective. So so the adjective follows the noun, but in English we say a small field, not a field small. So we do it the other way around. So there's different rules in language, and these rules are all written down. But I would think these are informal rules because they are not related to laws in the legal sense, and therefore being written down or not is really not it's quite a weak distinction. And it's unnecessary too, because once we establish the formal-informal distinction on the basis of legally related or not, then we have a more or less clear way of distinguishing there, and we don't need to encumber this with other criteria. And what about institutions more generally? Institutions are systems of rules, broadly defined. That's a very, very short definition. We need to clarify it a bit more. But how does that relate to what I've just talked about? Well, formal institutions then are constituted or maintained through legally decreed procedures. Laws are the dominant elements in the rule systems. Now, we all know that law itself, the practice of law, has rules which are not necessarily passed by a legislature. I mean, there's things that are taken for granted in laws which may not be written down or even legislated. The question is, what's dominant? Is it basically a law-driven institution, or is it something else like language, which is not really legislated? Informal institutions might include phenomena like language, customs, rituals, table manners, things which are not basically about laws, at least in most cases. And most of their rules are not constituted by lawmaking institutions. There's a bit of fuzziness, there's problematic intermediate cases, but I basically think this would be a good way of going ahead and making the distinction. And I think this largely follows North in his earlier distinction, as I quoted. There's also the question of illegality, right? By illegality, I don't mean morally wrong, I mean against the law. Now, if formal institutions are based on laws, then all formal institutions are legal in a sense. But with informal institutions, some of them may be illegal. So we have mafias and criminal gangs, for example, and these will be illegal informal institutions. So both informal and illegal. We can also have legal informal institutions. So it's a sub-distinction of the informal category. Now, what are these implications? So I hope that basic distinction is clear and we can move forward and look at how these things relate to each other and why the distinction is important for matters like economic development. Sometimes informal rules substitute for ineffective formal rules. So in many countries, I mean, most countries, I guess, even in developed countries, there's rules which are not observed or unknown or badly formulated, and they're ineffective or ignored. There's to different degrees in different countries. We can find this all over the place. Now, what happens then? Well, sometimes informal rules substitute for informal rules. If you've got a very poor country, for example, with a very weak rule of law, then often the informal rules will be doing all the work. Basically, the cultural rules will be the rules that are relevant for most human interactions and behavior. Now, the prevalence of informal rules is likely to be greater if the formal system of law is corrupt or less effective. So with corruption or weak law or ineffective law, the prevalence of informal rules, the relative importance is going to be greater. Businesses can evade registration. In some countries, most countries, you must register a business. So businesses evade this, they go under the radar with state registration. They can avoid taxation, they can avoid safety standards, employment laws. And this is sometimes referred to as the shadow economy or the informal economy. Now, if you've seen any of this literature in this area, you know that these issues are very important. Debating the size and role of the shadow economy or the informal economy has become an important research question, particularly in development issues. What do we do about it? How do we judge the importance or the difficulties involved of having a large shadow economy or a large informal economy? One of the problems is that informality can harbor illegality. As I said earlier, if there's criminality, criminal gangs, these would be illegal informal institutions. So the rule of law is hindered by the existence of illegal informal institutions. The strengthening of many informal rules can undermine the power of formal legal rules. So it depends what you think about the importance of the rule of law. There's quite a bit of evidence that the rule of law is important, in which case, if the informal rules become too powerful or if they push back against formal rules, this can limit the rule of law, and that may be important for development. So there's a discussion about this. I would simply want to sketch the issues to underline the importance of the informal-formal distinction. So there's a scholar in this area called Clarita Gehani, and she reported there's a general agreement in the long run the informal sector should be reduced in size or formalized. The date of her work on this is her article was 2004, which is 22 years ago. But to show that this debate is going and different positions are being taken, I'll quote in a minute some other quotes which differ on this point. Gehani's argument means strengthening the formal legal rules to help reduce illegality in the so-called informal sector. Now, moving forward, this is 2013, so it's moving a few years later, we've got a quite different position from two leading scholars. Informal economic activities burgeoned across the developing world, particularly in Africa. You can notice the importance is for a whole continent where development is a crucial issue. They noted the events to limit the informal sector have largely failed. So instead of saying we should push harder or redouble our efforts, they tried to think of a different strategy. and that they said policymaking opinions shifted away from an emphasis on eliminating or absorbing the informal economy towards the politics of inclusion, whereby informal and often illegal activities are seen in part as an understandable response to state failure, showing the need for inclusive policies that accept the informal sector. So this is quite different from the previous position I quoted from Gahani. I'm not going to take a position, I'm simply going to show that this is a very important debate. And it hinges on the distinction between formal and informal rules and institutions. Here in the Mager and Lindell response, the legal is tolerated under the cloak of the informal. Again, the question is, I'm not going to answer it in detail, but the question is, how viable is this, particularly when you are promoting tolerance of illegal activity and therefore, consequently, undermining the rule of law? Maybe it's the only thing you can do, but it's worrying to think about what might happen. So the big question here is, can economies develop fully with a limited rule of law? I would suggest there's evidence that they can't, that they need a strong legal system, not too repressive or whatever, but a legal system that works to develop more fully. But that can be debated. My main point is the formal and informal institutions distinction is relevant to this very important development issue. In this section now, called the importance of good definitions, I'm going to say, well, I'm going to argue that we must be very careful about the definitions that we use. And I'm going to illustrate a point, that is that the slight changes in the definition can have very big effects about our conclusions. An American economist called Claudia Williamson, in a paper published in 2009, she wanted to measure the relative importance of formal versus informal institutions. So her conclusion was that informal institutions were relatively more important. Going into how she argues this, she used a measure of plurality, proportional representation, judicial independence, and constitutional review to estimate the strength of formal institutions. For her, understandably, it's a familiar argument, formal institutions involve constraints on the executive, legal constraints on the executive, and other things, and that for her became a crucial way of defining formal. So in the diagram, she has on the vertical axis all the countries in the sample. The little round circles each represents a particular country, and there's US GDP, purchasing power parity per capita in year 2000 data. I'm using her data, even though it's 25 years old now. And in this box at the bottom, with the hashed lines, we have a number of countries going from left to right: Nigeria, Egypt, Jordan, Indonesia, Bangladesh, Pakistan, Philippines, Uganda, Zimbabwe. The horizontal axis itself measures the strength of formal institutions by the measure that I just outlined. And what she finds by this measure is that, somewhat surprisingly, countries like Denmark, Finland, Iceland, Netherlands, Norway, and Sweden come with weak strength of formal institutions, according to her measure. And they do quite well, but there's a whole host of other countries here that also do well, which have strong formal institutions. So it doesn't seem that strength matters in terms of getting a higher GDP per capita. And those at the bottom with low levels of GDP per capita range from weak to strong institutions. So a basic conclusion is that the formal institutions don't matter so much as the informal. By her methodology and her definitions, formal institutions in the Nordic countries and the Netherlands are very weak, and roughly equivalent in strength to those in Nigeria. I think those familiar with those countries would actually question that conclusion, which is based on a particular measure, and we might look at a different measure. So I found a slightly different measure. And her approach stemmed from the narrow focus on government constraints as defining the set of formal institutions. Okay. So if formal institutions are defined more broadly as legal institutions, then we might want to measure them in a slightly different way. And one possible measure of their strength is an index of the rule of law. Okay, there's many sets of data with different measures of this, and one of these is called from Global-Economy.com. So I used that and compared the use of that data rather than Claudia Williamson's data. So now we have the same issue measured on the horizontal axis, which is the rule of law index, which now goes from -2 to +2.5, taken from Global-Economy.com for their data used for the year 2000. And we have exactly the same measures of GDP per capita as Claudia Williamson used for the year 2000. And the picture switches dramatically. The same countries at the bottom, Zimbabwe, etc., which were spread across here by this new measure, are more closely clustered together. They're not that close because there's a big range between, I think it's Jordan here and Zimbabwe on the left, but they're not as spread out as in the previous diagram. And the group Denmark, Finland, and Iceland, Norway, Sweden, come out top right, which means they have a high GDP per capita, which they had before, but that correlates very, very closely with the rule of law index. Incidentally, this rule of law index is a composite index. You can look it up from global-economy.com. And part of the one element in that composite is constraint on the executive. So it doesn't mean we're ignoring that important point in Williamson's work. What we're simply doing is taking a more balanced view of what the rule of law might mean. And we get a pretty strong correlation with an R-squared of 84% between rule of law and GDP per capita. Now, I'm not saying this is the best analysis that we could do of this. We could go much further. What I've done is, I think, demonstrate a point, is that is the use of a slightly different definition leading to a different data set, which has some similarity to the other one, but actually leads to quite different results. So it's a good moral here about the importance of very careful definitions and also choosing data sets that seem more plausible. Okay, so that's my next the end of that section. To repeat, the point here, the key take home is that refining our definitions is only part of the story. We have to use those better definitions to choose better data sets and be more careful about the data we use. Okay. Now we raise some other questions. There's some other words that actually cluster around in this area. Another word is culture. And one question which should worry us is because culture is often defined in terms of rules or norms, perhaps. So how do we distinguish the concept of culture from that of an institution when both refer to rules and norms? Now, I think that's a good question, but I haven't got a clear answer, and I don't think we're anywhere near a consensus on how we would answer this. What we have is a number of options. I think it's important to be aware of the options and be aware of the difficulty involved here and work together to actually try and improve understanding here. So one option is to use culture as a set of traits found in several institutions. I proposed this in a book, 2001. What do I mean by this? What I mean is we can say America, the United States, that is, has a individualistic culture. Yeah, it sounds right, doesn't it? And in fact, people like Geert Hofstede, who's a great expert on differences between cultural features like individualism, hierarchy, masculinity, and so on. And he actually has got data on those variations on a country-to-country basis. And his data would say that, relatively speaking, the United States has an individualistic culture. Okay? So it's a meaningful way of thinking about the problem with meaningful data, which is there. It's not necessarily the last way of doing it or even the best way of doing it. But this is one way of referring to culture. So we can have formal and informal institutions, and then we can say, well, in America, the culture is more individualistic with these features found in social rules and institutions more generally or broadly. A slightly different approach coming from a scholar called Svetovar Petrovic. He proposed that informal institutions are traditions, customs, moral values, religious beliefs, and all other norms of behavior that pass the test of time we call culture. Okay? So basically, culture is all the informal institutions, more or less. So the two words, so we could substitute the word culture for informal institution. And indeed, that's what Alessina and Giuliano proposed in 2015, that they said we use one category, formal legal systems, formal regulation, and formal institutions, and then all the others, the informal, we call culture. Culture applied to values and beliefs and informal rules. So here, going a step further, the concept of informal institutions is replaced by culture. So basically, these are three attempts to relate the word culture to institution. I'm not going to promote any of them, even my own. I'm just going to say there's a problem here, and we should discuss it and try and work out a way of sorting out or avoiding misunderstanding. There's another problem, and that is the meaning of law. Okay, I've said that basically I would suggest we follow Douglas North, and say that formal rules are basically legal rules, or systems dominated by legal rules are formal institutions. The question then is, what do we mean by law and legality? Now, traditionally, in writings on this by jurisprudential scholars, like the English expert William Blackstone, in his commentaries, he said law is a rule of civil conduct prescribed by the supreme power of the state. That's a traditional view, to associate law with the state. But some legal scholars have moved away from that. One extreme over a century ago is the James C. Carter, one-time president of the American Bar Association, said law is customs. We have two extreme views here. Again, this has to be sorted out for clear communication. Others see law as a transcendence of custom. In other words, ordinary custom is not necessarily law. Customs can become laws, but people like Diamond and Siegel and Redfield have pointed out that custom doesn't necessarily become law because often customs may conflict and the legislature comes in to decide which custom is legal. Okay. So again, this is an open box of issues which cannot be resolved in one short talk. Coase you've heard of. He's another Nobel laureate for his work in institutional economics. He actually leant towards a more legally a view of law as involving the state. He said that with a vast number of people with very different interests, the establishment and administration of a private legal system will be very difficult. Hence, the state comes in. We may define modern legal systems as necessarily involving organized legislative, judicial, and enforcement institutions which are empowered by state authority. A law is a rule sustained or enforced by a legal system, as thus defined. Personally, that would be my preferred view to go along with that. Therefore, formal rules are actually potentially enforced by legal systems involving the state. Yeah, as I suggested earlier, though, there's complications. As Durkheim, this French sociologist, rightly pointed out, in a contract, not everything is contractual. In any legal proceeding, like making a contract with something, buying a service or a good, we take for granted a lot of the rules. We may not know them, but even if as many rules as possible were written down and became laws, there'll still be other rules that would escape codification or would escape being enshrined in law. And the rules like you must be of good faith with someone and you must allow them to express their opinions and so on. All these social rules we rely on are necessary to make the legal system work. So in a contract, not everything is contractual. So all legal systems include informal rules as well. So there's still more work to be done on problems like that. Let's now look at a very specific problem, and that is, how do formal and informal institutions interact? Now, there's a classic state on this by a third Nobel laureate in institutional economics. This is Oliver Williamson, in an article in the Journal of Economic Literature in the year 2000, 25 years ago. This diagram is often quoted. And the writing may be a bit small, but I'll guide you through it. He has 4 levels. And this highest level here is informal institutions, customs, traditions, norms, religion, and so on. So these are things which are not necessarily laws, basically customary rules. And his case is at the higher level. The frequency is very long of change, and they change very, very slowly, okay? And then we have rules of the game like property rights, judiciary, and so on. These change more rapidly, and they have formal properties, or at least some of them do. And then higher level is governance, governance structures with transactions. These can be changed much more easily. If we start up a company, for example, we can structure it in particular ways. We can do this relatively quickly within the law. And then even more quickly, we have prices, quantities, resource allocation, the ongoing changes in an economy, and these are continuously changing. So our purposes here, the key point is that according to Williamson, customs change very slowly, but legislative and other things, laws, can change more quickly. Now, broadly, that's right, but there's important exceptions. We have lots of evidence supporting, with case studies, of the persistence of cultural traits or informal institutions and their lasting effects. For example, work by Emmanuel Todd, French sociologist, on family structures and property inheritance patterns, seeing them persisting in different parts of the world. These are informal institutions about family relations, like what's the norm about, do cousins tend to live with each other, or do they separate off? Do they have smaller nuclear families or bigger family structures? And this relates to the question of inheritance, whether it's more egalitarian, whether it's male-centered, and also other rules like is it primogeniture, the oldest male or whatever. All these things matter. They're not necessarily written down in laws, and they persist remarkably over centuries. Okay, that's Todd's example. So that confirms Williamson's claim that cultural rules change only slowly. David H. Fisher, an historian, he traced cultural differences in family structure, gender relations from different phases of immigration, from contrasting cultures in different regions of the UK. That's a fascinating work. Another example is work by Salomon and Kirby, and they found that different patterns of farm management, land tenure amongst Illinois farming communities, depending on whether they were of German or British Protestant descent. They did things differently for reasons going back maybe 100 years or more. A similar study in the US, Nisbet and Cohen, the survival of a violent culture of honor in the US South, reflecting cultural values which were imported over, mainly from Britain, from parts of Britain where there was a culture of honor. Because Britain is regionally varied, or was at least at the time of the migration. So these all endorse Williamson's notion that culture changes only very slowly. But can informal rules, culture, change more rapidly? Perhaps through the influence of formal rules. There's two questions there. Can culture change more rapidly, and would it change often because of the top-down influence of formal rules? One example has been modeled by these authors, Aldashev et al. They modeled how formal law can actually pull custom in this direction and causing a progressive evolution of prevailing mores. And they call this the magnet effect. That's the model of it. Have we any examples? Well, Milgram showed how people can be manipulated to obey authority. Is his famous experiments on authority carried out at Yale University showed that people are very responsive to authority figures, which is quite scary because that shows that if we had a Nazi regime, many people would cooperate with it, even if they thought it was wrong. And Tyler also stresses the importance of formal institutions, law, and people's compliance with it. More specific historical examples consider the Chinese practice of binding the feet of women. It lasted 1,000 years, but within a generation it disappeared, largely due to strong bottom-up social campaigns against it. The cultural shifts are often pressured by economic or legislative changes. For example, in the post-Second World War period, many countries have gone through major changes in the structure, including the gender structure of their workforces. So in the US, female participation in the employed workforce rose from 33% in 1950 to 60%. It more or less doubled. And it's argued that this prompted feminist movements and eventually leading to equal gender rights legislation from the 1960s onwards. In other words, the changes in the composition of the workforce, which weren't necessarily a result of law, led to legislation about gender rights as a result of those important shifts. Another example is from Britain, British social attitudes. In 1990, 69% of adults thought that homosexual acts were always or mostly wrong, compared with 19% saying they were really wrong or not wrong at all. Now, this is only 35 years ago, with a clear majority of adults saying in 1990 thought that homosexual acts were wrong. In other words, there's legislation which needed some attention. I mean, homosexual acts were legal in the 1960s. There's other things going on about which were allegedly discriminatory, and attitudes were quite against change in many cases. Only 20 years later, in 2010, we find 30% saying that they were almost mostly wrong, which is less than half, as it was in 1990, compared with 53%, which is more than double, saying they were really wrong or not wrong at all. So you've got this complete shift in opinion in a relatively short period of time. Why did this happen? Well, we need to do more work on this, but one hypothesis would be there were a number of legislative acts, including reductions in the age of consent for male partners in 1994, bringing it in harmony with for heterosexual couples when they can legally have sex. And two phases, 1994 and 2000. The ban on gay people serving in the armed force was repealed in 2000. Instigation of gay partnerships in 2004, and the banning of discrimination based on sexual orientation in 2007. So between 1990 and 2010, when this big shift of opinion occurred, a number of legislative acts gave more rights to gay people. I would suggest that these two things are connected. The legitimation of being gay and gay activity on an equal basis to heterosexual couples was an important motor of change public opinion, as reflected in the polls. That's a suggestion, but I think it's too strong to be merely coincidental. Of course, it wasn't just legislation. There was a popular movement for gay rights, going right back several decades. To point out further, some rules and attitude that are seen as cultural may actually begin historically from laws and formal institutions. For example, there's a book by Martin Weiner in 2004, and he argued that English culture was resistant to industrialization and economic growth. In other words, the more influential, the richer end of British society or English society was resistant to industrialization, manufacturing, and economic growth, and was wedded to staying in the countryside, having a great house in the countryside, and so on. But actually, this came from law. English feudal laws made land ownership important, indeed vital, to become influential. Another example, 1742 legal code in feudal Japan. This was an important change. If we think of Japan, if you've been to Japan, there's aspects of Japanese culture which come across as quite distinctive and important. And one is, for example, the people refraining, the rarity of legal dispute between people. They try and sort things out by talking to each other rather than threatening the courts or going to the courts. So where does that aversion to litigation and propensity to compromise come from? Well, in 1742, there was a legal code, and it was not designed to deal with disputes or contracts. Instead, informal settlements or compromises were encouraged, sometimes by the threat of state punishment of both disputing parties. So instead of changes in English law, for example, which enable contracts to be properly executed, to be properly reached and to be enforced. The legal code in feudal Japan simply said a plague on both your houses. You shouldn't be doing this anyway. We'll punish you both if you argue with each other. It's quite a heavy punishment for bringing about legal disputes. So it's possible that customary Japanese aversions to commercial haggling and litigation may result more from draconian legislation to prevent such disputes in the 18th century than from earlier traditional practices or beliefs. Another candidate explanation that, in fact, law can affect culture. That's the point I'm making, that the causality can go in both directions. Okay, to tie everything up, I've stressed that definitions are important, and we should teach our students more about how to construct them. It's an important part of learning, particularly in the social sciences. Slightly different conclusions can lead to dramatically different definitions can lead to dramatically different conclusions. I demonstrated that with my examination of the work of Claudia Williamson. The terms formal institution and formal rule are best associated with potential legal enforcement by the state, or law in short. Other factors such as written down are unnecessary in this definition. In fact, they confuse matters. And formal and informal rules interact in different ways. Well, Williamson seems to be right in his observation that many customs are very, very slow to change, and we have evidence of very slowly changing customary rules which last for decades or centuries. There's also special cases where that's not the case, and in particular where formal rules may affect culture. Informal cultural rules are not always slow-moving. Thank you very much indeed.
Thank you very much, Professor Jeffrey Hodgson. We will now move to the discussion session. Before that, I would like to say that the aim of the seminar is to build a bridge between institutional studies and the analysis of the migration phenomenon, encouraging a theoretical and empirical dialogue that contributes to the critical analysis of the migration policies and to the development of more inclusive approaches. Well, first Professor Bruno Gandlgruber, followed by me, and finally, Professor Jorge Culebro.
Hi, Jeff.
Hi, nice to see you.
It's a great pleasure to see you and to be together in this session. I have to say it was your work and your contribution to what we are doing here at our department was fundamental. It was really crucial. So there are many ideas, texts of yours circulating and being discussed. So to be able to continue this is really a great pleasure. So and I think it's also another step in getting a deeper, broader understanding of the general importance of institutions for economic and social life, and particularly for states, for societies like Mexico, where we are really struggling with weak institutions and with finding ways of building reforms for problems, social and economic problems in all kinds of areas of society, and where a deeper understanding of the combination of formal reforms, of policies, of laws, without changes in the informal background is always insufficient, and also the other way around. So the question of how we can integrate changes in the formal structures of institutions and at the same time in informal processes of social construction of the underlying ideas is I think a fundamental problems for economies like the Mexican economy. Now you build here in your specific argument in this presentation on the tradition of Douglas North, following some earlier work where like he discusses conceptual aspects of his general work, so to propose a more rigorous definition that is anchored in a legal criterion. So an institution is formal if its rules are potentially enforceable by a state-backed or publicly backed legal system. So everything else would be informal. Now I think we have three main ideas in your presentation that I would like to briefly resume. The first one would be that the distinction between formal and informal institutions should be grounded in the criterion of legal enforceability by the state, not in whether rules are written down or deliberately designed. The confusion that we have in the literature leads to contradictory empirical work and empirical results. The second one, I think, is the choice of definition in these important matters radically alter the empirical findings. As you show by the comparison with the two measurements of formal institutions between Williamson and the rule of law index, the results can be really opposite if we part from different definitions. So contrary to the dominant view, these informal institutions change slowly, show that certain conditions, especially when legislation is perceived as legitimate, informal norms can transform also rapidly. I would like to pass to some questions, some specific questions that, in my point of view, can be raised as applications to cases, empirical cases in the Mexican contexts. So first question, your definition of formal institutions rests on potential legal enforceability by the state. But Mexico presents a case where the same state selectively enforces rules depending on the actor, on the sector, or on a region. That a phenomenon that's been called discretionary formality. So labor law, for example, formally prohibits now outsourcing, subcontratación, in most forms since a new law from 2021. But its enforcement remains uneven across states and industries. So does potential enforceability still demarcate the formal, if the formal part, if enforcement is low or almost zero for certain groups? What would be the consequences for your definition of informality also. Second question. Your analysis shows a strong correlation between rule of law indices and GDP, the P per capita. Now, Mexico consistently scores in the lower middle range of these indices. More importantly, Mexico scores very differently across different dimensions of the rule of law. For example, we have a relatively higher one on regulatory enforcement and constitutional review, but a dramatically lower one on topics like corruption or civil justice. So what does aggregating these different dimensions into one index mean or reveal? How could we handle with your framework institutional environments that are so diverse and contradictory? And maybe a third one. You talk about that inclusive narratives that about the informal sector may normalize illegality and erode state capacity. In Mexico, the informal sector employs more than 55% of the workforce, a figure that has remained stable for decades despite economic growth, formalization programs, and labor reforms. This suggests that informality is a complex phenomenon that's related to failures of governance, to problems in characteristics of the labor markets and underlying values. How would you use like your framework to analyze these kind of complex problems? So now you cite the risk that the toleration of an you say like this: the toleration of an expanding informal sector may exacerbate the problem of partial state failure. Mexico's experience with the platform economy, but also with new forms of organization in agriculture markets, as we've been discussing here on this table, show certain tensions there. So there are workers that are formally employed with contracts, but that lack social security, that lack collective bargaining rights, and that lack a stable income. So in these contexts of, like, let's say, new forms of informality that are located within formal arrangements, how would you classify these phenomena within your framework? These irregular arrangements within your framework. Well, I think I'll leave it with this question for this round to have some space for further development and questions by my colleagues. Thanks again so much, Jeff. It's incredible to see you.
And to you too.
Thank you, Bruno. It's my turn. I'm pleased to greet Professor Jeffrey Hodgson and everyone joining us for this seminar. Here we go. I have been reflecting on the Professor Hodgson's article, and I found that it offers a valuable analytical framework for analyzing the hiring processes of undocumented agricultural workers in California, United States. In recent studies, such as those by Barron and Ojeda, evidence was found that confirms Durkheim's assertion, cited in your article, that not everything in a contract is contractual. As you note, legal systems are inherently incomplete and leave room for custom and culture to play a decisive role. In the agricultural labor markets of California, where undocumented farm workers are hired, this becomes particularly visible. Although the law establishes that all workers, regardless of their immigration status, are entitled to the same in the same protections, including minimum wage, overtime paid, and basic labor standards. In practice, informal rules keep on shaping hiring and compensation in decisive ways. For example, in Oxnard, it's customary for new workers to be paid $1 less per hour as a way to observe their performance in the fields. In regions such as Watsonville, Salinas, and Greenfield, this practice results in differentiated wage schemes for newly arrived workers compared to those with more experience. Similarly, these deep tensions between formal and informal institutions in agricultural fields are not limited to the experiences of the workers themselves. They also appear among the ranchers who hire laborers through the H-2A program. Many of them report that whereas in previous administrations, the procedures of obtaining permits and visas were typically resolved within approximately 1 to 1.5 months, allowing employers to plan their applications in advance. During the Trump administrations, these processes were significantly prolonged and now often take up to 5 months to complete. This delay has generated uncertainty and disruptions in the availability of labor, which in turn has led a growing number of ranchers to rely once again on undocumented farm workers to meet their productive needs. Based on the reading, I would like to ask one question to Professor Jeffrey Hodgson. Elinor Ostrom argues that collective actions constitutes a key institutional mechanism for addressing asymmetric contractual arrangements. However, her work doesn't delve deeply into the role of institutional leadership. What role do you believe it can play in the formation and sustainability of more balanced institutional arrangements? Thank you very much. Now, it's Professor Jorge Culebro's turn.
Thank you very much, Dr. Ada. Thank you very much, Professor Geoffrey Hodgson. It has been very useful conference. And in a way, we're very happy because talking with some colleagues, we arrived to the idea that it's like reflect upon about institution in Department of Institutional Studies. Well, it's become very important for us to think about that. There are some points and questions I would like to say. The first one is that this distinction between formal and informal institutions, there has been a long discussion about that, which is more important, which is better or not, etc. But I think one of the reasons is that it is important to have this distinction because it has some implications in economy, political issues, but also in the context of our seminar, it has very important implications in terms of migration because it's not the same to think about illegal immigration or informal immigration. These distinctions has different implications and impact in this population, and also in the political atmosphere of the country. So in that respect, I found very useful and interesting to talk about this distinction between formal and informal institutions in the context of this seminar. I guess also I have some points is related with this idea of, well, it's not in representation, but I like to question about the autonomy of institutions. The question is, if you think that the level of autonomy of institutions is related with the distinction formal and informal institutions. I mean, can we think that informal institutions has more level of autonomy, or probably formal institutions depends on the ways how they are created? They are more autonomous. I mean, but this distinction or this relation between autonomy and the degree of formal and informal institutions, I would like to know more about that. And I think also when you talk about the distinction, or when you talk about the relations with law, I think it was very useful, especially because in our department we have a bachelor's in law. Actually, in some of the courses, we discuss about how law is created and how the meaningful and relations with moral and other issues. But perhaps there are some problems because it's difficult. No, it is not difficult, but there are some things to think about when we talk about institutions, because there are also different types of law. I think it's not the same, for example, private law, public law, and perhaps public law is more related with formal institutions, and we may think that private law is more related with informal, but they are not the same. But I think we can think more or reflect more about the meaning of or relation between formal and informal institutions and law. I think there is a long way to think about that. And finally, I just found that the decision between formal and informal institutions, it is also related with a similar point of view of the logic of appropriateness and the logic of consequences, in the sense that formal and informal institutions, they don't exclude each other, but I think they complement each other in a way. So I think that in some cases they complement. Sometimes we have a first an informal, and they become formal institutions. Sometimes we have in the opposite way. We have some formal institutions that they don't work effectively, and they transform in informal institutions. And more of this related with this two logic of appropriateness, logic, and consequences. And finally, my only last point is that I thought it's also this between formal and informal institutions is also related with the level of analysis. In some cases, it is easy to understand or to see this distinction at the organizational level, but then when you arrive to the international level, it probably becomes more difficult, because the international arena is different than the organizational one, and especially in these moments of war, care, and everything. So it's that's are my comments and my two questions that I would like to address. And thank you very much, Professor Geoffrey Hodgson, because we allow us to think and reflect upon about the role of institutions, which is also very important for us. Thank you very much.
Thank you very much. Could you answer these questions?
Yes, I mean, thank you very much for those questions. They're really, really important and hard to answer, okay? There's no easy answers here. Perhaps I'll go in reverse order with the questioners, and I'll deal with Jorge's excellent points first. I'm glad he and also the second questioner underlined the fact that some of the concepts I'm using or proposing, the framework I'm proposing, has some use in the migration context. I mean, I'm unable to really speak in detail about migration issues because I'm not an expert in the area, but I'm very pleased to hear that you find these ideas relevant. I was hoping for that. One question you raised was, what about autonomy? Is there a relationship between formal and informal? Does it parallel autonomous or less autonomous? Well, basically, I don't think it does. I think autonomy is an important question, but it's rather unrelated to what the rules are, because if the rules are global, then they may limit autonomy, and the reverse. The rules are more specific, it provides autonomy. Your point about the difference between private and public law, I think, is very important, and perhaps it's a mistake, but I don't go into that in the article or the presentation. But basically, public law applies to everything. Rules govern everything. Private law relates specifically to a zone of activity, like within a corporation or within a society or within a family or something like that. And that those laws can vary from case to case. So when a company sets down its rules, it's subject to corporate legislation, maybe nationally, but the specific rules it has may be specific to its corporation. But they're all legally enforceable in the sense that the state could step in. If a company has rules which are part of its registration as a company with the state, and those rules are contested or broken, then the state can come in, and because it's partly a breach, it could be a breach of contract, and the state can step in with that. Private rules made about a contract become the subject of the state intervention or enforcement if rules are broken. So yeah, I should have said that in the article perhaps, and it's a very, very important distinction, but I don't think it means that private law is informal. I think it's still formal because you have the ultimate authority of the state still involved. Okay. On the question of affirmative action, I'm really not sure the answer about that, whether that's relevant, particularly in the cases you mentioned. So forgive me, I'm not sure how I would answer that question, but I'm very pleased you said that Durkheim is important. I think this insight from Durkheim, basically what Durkheim was doing, he was criticizing a English philosopher called Herbert Spencer, and Spencer said that everything is contract, everything is a deal between people. I mean, other people still say that these days, basically contracts are everywhere. And Durkheim says basically that's impossible because two people coming together to make a contract cannot know all the issues involved, and they make use of informal rules all the time, even when making legal contracts. So I strongly agree with that point. Now, Bruno's questions are very, very hard. I'll leave the hardest to first. I mean, first of all, you talked about the Mexican case. Now, I don't want to appear here as being able to lecture everybody about the right way of doing things. In my country, it took hundreds of years to get a working and relatively uncorrupt legal system. It's still highly imperfect. Corruption in the UK, in Britain, was rife until more or less the end of the 18th century. And then it was diminished, partly because of the need to fight wars and the need to have an efficient military, which was free of corruption. That's one theory anyway. So I'm not going to preach and say that we know the answers. We don't. It took hundreds of years. In the British case, we should be much more patient with other countries when they're going through problems of development like this. Basically, we have to learn from experience. And a crucial issue involved relating to this particular question is the importance of laws that are on one hand general, like the public law concept that I raised earlier, and laws that are not meant to be general, like some private laws. Okay, and so discretionary formality is a case where general laws are interpreted and enforced unevenly. Okay, and somehow you have to build a system where that's less and less the case. The unevenness in enforcement is less and less true. Now, in every country has problems of this kind. We in this country have problems in Britain, have problems of uneven enforcement and even corruption. And so I'm not saying it's easy to do, or the particular countries, and no country is free of such problems, but we have to learn from each other and work towards a better system. The second point, I was not advocating composite indices for everything. I was simply using a composite index of the rule of law to illustrate that if you change the variable slightly, then you can get radically different results. So that's simply a demonstration of that, what it says on the tin. Redefining slightly can lead to very different results. If you ask me the question, what do we need then for analysis? I would say you need to disaggregate. Lumping the rules of law together in one index is of limited use, not of no use, but of limited use. We have to disaggregate and see which elements matter and see how they matter in particular contexts. So I fully agree with you that we have to disaggregate and limit aggregated or composite indices, because they sometimes don't tell us really what's going on. On the question of the large size of the informal sector in Mexico and also in many other countries, it's quite a bit lower than 55% in my country, but it's certainly there. It exists. People working under the radar legally and so on. It exists in every country. It's important that we regularize it and implement it. And I'm thinking about your questions about the real challenges faced by all countries, including developing countries. I have in mind De Soto's attempts to create property registration in Peru and to give people rights of land ownership, which are poorly defined, so by land registries and so on. I think it's all really interesting work, and I give credit to De Soto for focusing on it for over 20 years. But actually his experience of trying to get things working in that direction in Peru has had limited results, and quite rightly he himself points out, as early as his 2000 book, that doing this is hard and we really need public support to get it done. It can't all be top down. He makes that very, very clear. How exactly you do it, I think nobody knows exactly. Certainly I don't, and Soto gives us a lot of experience of what can be done and what can't be done. But I think getting public support is crucial, and it's a need to actually bring these kind of issues down to the public level. It's a matter of partly of education, it's a matter of community experience, it's a matter of advisors coming in and saying what the options are and giving advice. And it's also a matter of cleaning up the state. You can't remove corruption entirely, but minimizing it as much as possible, getting people to adhere to rules, getting the state to clean up its act to avoid major elements not only of corruption, but malfeasance and misapplication of the law, which happens everywhere, but they must be minimized. So this is the big agenda. All countries face it to a degree now. Some countries are busily undoing their efforts in the past. I think of the United States, where the rule of law is becoming eroded internally by leading figures in the United States. So this is really a big problem. There's no easy answers, but it's basically a matter of experience, education, learning from experiments, learning by doing, and basically appealing to people, we're in this together and we have to work together to improve our institutions. Thank you for your questions. They're great.
Thank you very much, Professor Geoffrey. Next, we will open a brief space for questions from the audience.
Very interesting, Professor. I would like to know more about Durkheim perspective on contracts and informal rules.
Sure. Okay. Yeah, I think contract law is very important and very interesting. I mean, the invention of a contract took hundreds, if not thousands of years to develop. And the modern law of contract involves a number of recent changes, and different countries have different rules. But basically, a contract is a mutual agreement between parties of making commitments, not necessarily to exchange things or to move property rights. That's often the case, but basically two or more parties come together and they make commitments. Okay, and that's recorded or accepted as a contract, and it becomes enforceable. So it gives the parties incentives to do what they're committed to do for the other party, and therefore it's a great mechanism of economic decentralization. There's problems there, of course. There's many big problems of information. Knowing what exactly we've agreed to, knowing what exactly the problems are, dealing with issues like risk and uncertainty, making insurance, right? So people bring in insurance clauses in contracts. So if something happens and you agree to do something different. And then there's also the underlying Durkheimian issue of the values and beliefs and take them for granted things that we take for granted, but may become very important and often are substantial to the contract being performed. So all those things are relevant, and they're relevant in Mexico, and they're relevant in my country, relevant in other countries. We have a basic framework of contractual law originally influenced by Roman law, which has been modified and modernized. Another problem, as well as the information problem, is, I think, asymmetry of power. So you have two people making a bargain, and one may be in a much weaker position than the other. So, for example, a worker needs a job, and they enter into a contract with an employer, and because the employer has a choice of many workers, but the worker may have only one or two options, and that puts the employer in a much more powerful position. So I think that's really a neglected problem. It was raised by some American lawyers like Robert Lee Hale in the middle of the 20th century, but I think asymmetric bargaining power should be added to information as a major problem in employment in various contracts, including employment contracts. And that's relevant in your country and it's relevant in my country. We have lots of cases of asymmetric bargaining power. So that raises questions about state regulation and protection of people like workers and employees and poorer people who might become victims of an unfair contractual agreement. An unfair contractual agreement can be within the law, okay, unless there's legislation to limit such practices. So contracts then open up a huge set of questions. So again, the strategy should be to recognize the importance of informal cultural ties alongside the importance of the law itself, and if necessary, making new laws to help contracts work in everyone's interest, or at least in the interests of both the parties rather than one party. That's a big issue you raised. I'm not sure if my answer is adequate, but thank you for the question.
Una pregunta más.
No sé si hay alguna otra pregunta.
Pues yo solo lo voy a hacer en ese momento. Sí.
Sí, sí, sí.
Perdón,
Ahí
gracias.
está.
Hola, buen día, doctor. Muchas gracias por su compartir, por la conferencia. Bueno, yo más bien solo que quisiera un poco bajo el compartir de la presentación de usted, pues me evoca muchas reflexiones, como bien compartía el doctor Bruno, en torno a la realidad.
Doctor, no puede escuchar. No escucha. ¿Cómo lo vamos a hacer?
¿Alguien?
El audio de ambos. Solo que yo apague su micrófono.
Ajá, si quiere, a ver, permítame.
Adjustments. Can you hear me? No me escucha. You can hear me. We had to make some adjustments because the Zoom was not programmed for interpretation. So I'll be translating consecutively.
Gracias. Bueno, la pregunta puntual es, en México se establecen relaciones laborales sin un contrato de trabajo formal, sino más bien apalabrado en los trabajos agrícolas en el territorio nacional.
In Mexico, in agriculture, there's no formal contract. It's just a word-by-mouth contract. ¿Y cuál es la pregunta?
La pregunta sería, bajo estos enfoques institucionales, ¿cuál sería la propuesta que usted nos podría hacer en torno a la realidad de México?
So what proposal could you make, regarding the reality of Mexico where contracts are made in this way?
Okay.
Is it clear?
Yeah.
Okay. That's a great question. Thank you very much for that. Basically, if there's no formal contract, then maybe that may offer flexibility and there may be possibilities of mutual understanding. But basically, the workers, the agricultural workers that work without a formal contract have limited legal protection. Okay, they may have some legal protections because of general rules, but under employment law, they lack the legal protections. Like, for example, holiday entitlements or paternity rights or minimum wages. None of those things, if they existed in law, would apply to persons who didn't have a contract. So I think that's an important question for reform, and it's easy to say, but very hard to do. It would be an example of working bottom up to educate both employers and workers of the need for some formal arrangement that protects the worker and also protects the employer, as other countries have got. We have many templates for agricultural employment that would apply. So it's basically a question of people doing the hard work on the ground to persuade people to do this. I'm bringing top-down legislation, as I said earlier, generally won't work in these circumstances. It must be a bottom-up process. I assume Mexico currently there's the possibility of trade union organization, but I know in many countries, including South American countries, Central American countries, it may be formally allowed, but you would face dismissal or repression or violence or something like that. So, but that is one way of looking towards trade union activity to help protect workers and bring in more formal contracts.
Okay, so I think we are out of time now, so we have to close. Well, thank you so much, Jeff, for this inspiring talk and always bringing up such a systematic analysis for deep questions in institutional analysis. And I would also like to thank Ada for the organization of the session and the event, and the whole support team, translation, and people from our university who are making these sessions, these events possible. Thank you very much. Thank you for everybody participating. Thank you for your questions. And we go on with next activities. Thank you, Jeff.
Thank you very much.
Thank you very much.
Thank you, Professor Geoffrey.
You're welcome.
Bye-bye.